Hello everyone. Today I, Shivang Joshi, co-founder of Law Community, welcome you all on Lawyer Speaks. Today we have invited Mr. Samir Kumar, who is an advocate on record in Supreme Court of India, and his area of expertise involve corporate disputes, arbitration, contract violation, and many others. We are going to interact with him to know more about his journey and learn from him.
So my first question is, what factors influenced you to choose law as a career? How was your law school experience?
Actually, my father is also a lawyer. So I had seen him preparing the brief and preparing the arguments for his clients. So he is a practicing lawyer, still is practicing in Samastipur, Bihar. So I basically belong to Samastipur in Bihar. So I was interested in law. Actually, I saw my father as I told you. So after I completed my graduation. I immediately appeared for this entrance examination in DU CLC Campus Law Center, and in 2008 I completed my law. So it was a very good experience because when you see CLC Campus Law Center particularly, there are so many UPSC aspirants, so it was a good amalgamation of all kinds of students, students who are interested in law, students who have taken admission in law just because they are doing UPSC also. So they will get room in hostels, DU hostels. So it was a mixed experience, but the teachers were very good. They were thorough with their knowledge, and they had very deep experience in the field of law also because so far as procedural law is concerned, there were some teachers who were practicing there in the Tisazari, High Court, the Supreme Court. So they used to come and teach us. It was a good experience because it was hand-to-hand experience, how they feel while arguing the court, how to prepare the briefs. It was a good experience in the college.
How did you go about acquiring knowledge about such different fields of law?
See, when you become a lawyer, you can't say that I will practice in this field or that field. It all happens when a client comes to you. Maybe you are doing it for the first time, but since it's your first client, so you start taking interest and you want to win the case for your client because it's a matter of, I will say, it's a matter of ego for you also because it's your first case. So when you take so much interest in the matter, you prepare it so well, you don't think about money, how much you're getting it because it's your first case. So it all starts with your first case, and then you become used to it. You appear in matters, you gather experience from your colleagues, your friends, how the other side is arguing, how the judge is behaving. It's all about experience in court because you can read so much in books, you can read so much on internet, but the real court experience is the thing that makes you a lawyer. So when you work in different kind of fields, different clients approach you. So do you do NCLT matter, this civil side, criminal, and so you do all kind of matters, and this is the way you get to learn all those things.
My next question is, how do you think real estate policies and property laws have transformed over the years?
The much change came with this RERA because earlier you were only dependent on this property law and contract law basically because there were nothing much to regulate these builders because if you can just experience it in 2005 and 2004 around when there was so much boom in property in Delhi NCR and all over the India, so there was no law regulating these builders. They promise you that we will deliver you the flat in 5 years, 4 years, but after that it takes around 10 years, 15 years. You go around to the courts, you meet the lawyers, but you don't get the desired relief. But after advent of this RERA, it all has become very easier for the people to drag them to the court, RERA court, saying that sir, this is the problem, and they have to either give you back the money or they have to just build the floor, everything. So they have to deliver the flat. So that's the thing. So far as property law is concerned, property law, I won't say that basic principle has changed. It has remained the same, but RERA and other things like flat bats also associations are now approaching NCLT. So it's a good thing. Now we have seen a sea change when we joined the practice in 2008 and nowadays. So after this advent of RERA, I just told you, so it has got a sea chain now.
So, what developments would you propose in this field?
See, developments, there are good developments already taking place, but I would suggest you, being a flat buyer myself, that when you approach RERA also, these builders would always make an excuse. This is the scenario, like we are facing this problem, we are before the NCLT, we can't do it, we will be devastated if some orders are passed. So it also takes 3 months, 6 months. I mean, you have to go around to the RERA court also for 6, 7 months. So there is no shortest way possible. Then you can drag them and say, no, you have to deliver it to me today itself. It depends on so many several things. So you can't say so. There is no, available remedy, immediate available remedy to us. So people have to wait for some time, and they have to be very vigilant what property actually they are going for, whether it is viable. They have to check the background of the company also. You can't go and just put your money in any with any builder. So that's the important thing. So law will help you only when you help yourself. So that's the basic thing.
So, my next question is, do you think white collar crimes by way of corporate frauds have considerably increased in the last 5 years?
See, it's not about 5 years. It's been in India, in all over the world for years. Because where there's an economy, you have corporate frauds everywhere. Now, in these 5, 10 years, we have seen there are so many cases, 2G matter, coal matters. But the point I have experienced is that it does not reach to its culmination. What happens then? You file a case on basis of assumptions that this is a fraud, this might be a fraud, but ultimately the court acquits all the accused. So ultimately what you get? Nothing. So you have to prepare a good case only on the basis of assumption or political prejudices. You cannot file a case against anyone. So, I mean, this is a basic problem with this corporate fraud law, because you say this is a fraud, but you are not able to prove it at the time of trial. So ultimately, you have to prepare a case where you have every evidence against the accused. Because once you file a case saying that it's 100 crores or 1,000 crore, lakh of crore rupees involved, people show interest in it. It is all there in the media, television, political debates, TV debates. You find it everywhere. But after 1 year, when the matter reaches to the trial, everybody sleeps. Nobody takes care of it. What's happening in the matter? Ultimately, all the accused are acquitted. That we have all seen in Colgate and 2G matters. So I will say that prosecution has to think about it.
My next question is, how important do you think is the arbitration procedures in litigation?
The future is arbitration, because in almost all the agreements that I see today, there is an arbitration clause, and it's good thing, because what I believe that if both the parties can approach a neutral arbitrator and get their disputes resolved, there is no point approaching the court and taking adjournments for years, because there is a time limit, as you know, in the new arbitration law. So you have everything, you have to complete everything within a fixed period. So I think that future is arbitration litigation only, not court litigation, because it takes so much time. It takes years for evidence, for framing of issues, everything. So it's a lethargic process. Basically, CPC, if you see, it takes 35, 40 years to complete a case. And if even after 35 years, the case is yet in the appellate stage. So I would say that this arbitration proceeding, it takes much lesser time, and so it's better, and it's the future of India.
So, do you prefer ADR system more than the traditional judicial procedures?
Yeah, definitely, so far as only civil cases are concerned, because in criminal court you can't have this ADR system. So definitely, so far as civil cases, I would always prefer this ADR system.
What advice or suggestion would you like to give to those professionals who have just started their career in law?
I would suggest one thing which I have done. You have to do your case and worked with a senior for at least 3 years. Not designated senior, but a senior who is practicing there in trial court, in high court, and in who is doing arbitration matters also. So you have to learn things from him, because if you start on yourself, you might not do justice to your clients. So it's better that if you learn with your senior, if a person, a colleague who has much experience than you, so you will learn things. And never join a very, senior old age wise, because you won't feel comfortable with that senior. If you have to start, you can start with 10 to 15 years of practitioner. So it would be better because you have a comfort level with him, and you will learn things, and he will be also very keen to make you learn all those things. Because what I have experienced, if you go to a senior who has around 40 or 50 years of practice, he won't give you much time because he does not have the time for you. He will speak less. He won't show much interest. Okay, because he does not have the time and for so many things. It's always better to be there with a senior for 2 3 years at least, so that you can learn the nuances of the practice. It's very important for you to practice in civil court, in high court, in other forums as well for 2 3 years. After that, you can choose your path where I have to go. I have to practice in NCLT or Supreme Court or wherever you want. But these initial years are very important, very, very important for you.
Thank you so much, sir, for having such an amazing interaction with us. It will definitely gonna benefit lot of young minds, and we are delighted to have time with you. And law community is grateful for the same. Thank you so much, sir.
Always welcome. Thank you. Thank you.